justices' ruling this morning. It conflicts with the Second Amendment's right to bear arms.
One proposal allowing them to carry firearms without a license.
The first major federal gun safety legislation in decades is now moving forward.
That law has been in place since 1913.
Picture yourself standing in line at a government office, paperwork in hand, waiting for a bureaucrat to decide whether you're worthy of exercising a constitutional right. You filled out forms, paid fees, provided references, and explained in detail why you need permission to carry a firearm for self-defense. Now you wait weeks, months, sometimes years, while some official you've never met determines whether your reason is good enough. For decades, this was reality for millions of Americans living in certain states. Permission slips for constitutional rights, subjective standards, arbitrary denials. But something just shattered that entire system. A Supreme Court ruling so powerful, so definitive, that it's not merely changing one law, it's demolishing the legal foundation that made those restrictions possible in the first place. And the implications are only beginning to unfold. The decision came down with unmistakable force. 6 justices in favor, 3 dissenting. But the significance wasn't just the vote count, it was the constitutional earthquake those numbers represented. A 6-3 majority isn't narrow or tentative, it signals overwhelming agreement among the court's justices that something fundamental needed correction. It sends an unambiguous message to every lower court in America: stop inventing excuses and start following the Constitution. For states that have spent decades building elaborate permit systems designed to make carrying firearms as difficult as possible, this ruling arrived like a wrecking ball. The case challenged what's known as a may-issue permit system, laws requiring citizens to demonstrate good cause or proper cause before local authorities would grant permission to carry a handgun in public. On paper, these systems claimed to serve public safety. In practice, they functioned as gatekeeping mechanisms where well-connected applicants received approval while ordinary citizens faced denial. The subjective standards meant that whether you could exercise your Second Amendment rights depended largely on the personal opinions of whoever reviewed your application. Some sheriffs issued permits freely, others refused almost everyone. The inconsistency was the quiet part, the feature, not the bug. The Supreme Court's response was devastating for these systems. The justices ruled unequivocally that the right to bear arms doesn't end at your front door. It doesn't depend on whether local officials personally approve of your reasons. It definitely doesn't require proving good cause to some bureaucrat's satisfaction. The decision resets fundamental assumptions that have governed gun laws for generations. If the Second Amendment protects something, you don't need permission. You don't need a compelling reason. You simply have the right. Understanding why this ruling matters requires looking backward about a century, because permit laws didn't originate as neutral public safety measures. Their history is far darker. After the Civil War, Southern states passed what were called black codes, laws specifically designed to disarm freed slaves and maintain white supremacy through force. In 1911, New York passed the Sullivan Act, requiring permits to carry firearms. The stated goal was crime prevention. The actual effect was disarming immigrants and the working class while allowing the politically connected to remain armed. Throughout the 20th century, urban states copied this model. High fees, subjective standards, impossible bureaucratic requirements, and courts that simply refused to intervene, treating the Second Amendment as a second-class right unworthy of the same protection afforded to speech, religion, or voting. By the early 2000s, states were divided into 2 categories: may-issue states where permits were routinely denied without explanation, and shall-issue states that were better but still burdened citizens with delays, costs, fees, training requirements, and endless paperwork. The current ruling calls that entire framework into question. Constitutional rights aren't rewards for good behavior, they're guarantees that government cannot arbitrarily restrict. This decision didn't emerge in isolation. It builds directly on a landmark 2022 case called Bruen, which fundamentally transformed how courts must evaluate Second Amendment challenges.
Members of the Senate are focusing on gun rights in the wake of the Supreme Court's Bruen decision.
The right to keep and bear arms shall not be infringed.
Before Bruen, judges used what's called a balancing test, weighing government interest in public safety against individual rights. Under that framework, states could justify almost any restriction by arguing it serves safety purposes, and judges typically deferred to those arguments. Bruen demolished that approach entirely. The court imposed a new standard: text, history, and tradition. Courts can no longer simply declare that a law feels reasonable or hide behind vague invocations of public safety. Judges must now ask a specific historical question: Would this law have made sense to the people who ratified the Second Amendment in 1791, or to those who ratified the 14th Amendment in 1868? The recent 6-3 ruling is Bruin's more aggressive successor, applying that historical test with full force not just to permit systems, but potentially to virtually every category of gun restriction currently on the books. It tells judges in unambiguous terms, stop inventing exceptions to constitutional rights, start honoring what the Constitution actually says and means. Within hours of the decision becoming public, states across the country descended into crisis mode. Some scrambled to rewrite laws to comply with the new standard, others dug in, preparing for prolonged legal warfare. California attempted to salvage its carry restrictions by massively expanding sensitive places where firearms remain prohibited, essentially trying to ban carrying across entire cities. New York passed legislation critics immediately labeled even more restrictive than what the Supreme Court had just struck down. New Jersey doubled down with additional requirements, including insurance mandates. Meanwhile, states like Texas, Florida, and Georgia leaned into constitutional carry laws, citing the ruling as validation of their approach. The immediate aftermath saw an explosion of litigation. Second Amendment advocacy organizations flooded federal courts with challenges to laws that had stood for decades, using the ruling as fresh ammunition against restrictions that could no longer be defended under the new legal framework. The result has been a cascading series of legal challenges, creating aftershocks that continue spreading through the judicial system. If you imagined that states hostile to gun rights would simply accept defeat, think again. They're fighting with every tool available, but their tactics are showing fundamental weaknesses. Some states are attempting to expand sensitive places to absurd levels, declaring airports, parks, churches, and even parking lots off limits for carrying firearms. Others are requiring liability insurance before permitting carry, imposing excessive training requirements with high fees and endless paperwork, or creating emergency laws designed to stall applications and delay court rulings. Here's the fatal problem with these strategies: none of them have historical precedent. Colonial America didn't have expansive sensitive zones. The founders didn't purchase insurance policies to bear arms. They didn't seek permission from British governors to exercise their rights. That absence of historical precedent is precisely why these new laws are already under withering legal assault. Courts applying the new constitutional standard cannot use old excuses to uphold restrictions that have no founding-era equivalent. The message is crystallizing. You cannot ban a constitutional right simply because you fear its exercise. The ruling didn't merely strike down one permit system. It redefined how every Second Amendment case must be judged going forward. It created what legal scholars call a bright-line test: clear, definitive, not subject to manipulation or judicial creativity. The framework works like this. First, courts must examine the plain text of the Second Amendment. Second, judges must look at laws from 1791 when the Bill of Rights was ratified, or from 1868 when the 14th Amendment extended those protections against state governments. Third, if there's no historical equivalent to the challenged law, that modern restriction cannot stand. Fourth, public safety arguments no longer override constitutional rights. They're simply irrelevant to the analysis. Fifth, all courts must follow this method without shortcuts or exceptions. This framework wipes away decades of judicial activism, where courts invented reasons to uphold restrictions. It reminds judges that their job is protecting rights, not creating loopholes. For gun owners, this means dozens of laws are now living on borrowed time. The Constitution is no longer treated as a living document subject to contemporary reinterpretation. It's being restored to its original meaning. The practical impact extends far beyond abstract legal theory. For everyday gun owners, this decision changes immediate realities. Good cause and may-issue systems are collapsing rapidly. Interstate travel for armed citizens is becoming less legally treacherous as more states may be forced to honor out-of-state permits. Traffic stops where officers treated legal carry as inherently suspicious are shifting. Carrying lawfully is now presumed constitutional, not grounds for suspicion. Even shall-issue states are facing pressure to evolve toward full constitutional carry. Citizens no longer carry firearms hoping the law is on their side. They carry knowing the Constitution protects them. The political firestorm has been immediate and intense. High-profile senators are proposing new federal restrictions. Blue states are attempting to redefine carry zones to make almost everything off-limits. Insurance mandates and special taxes on gun owners are being floated as workarounds. Red states are accelerating constitutional carry legislation. The 2026 midterm elections are already shaping up as a referendum on this ruling. This has transcended law and become about ideology, control, and political power. but the ruling's effects extend far beyond permits. Every major category of gun control legislation is now vulnerable to legal challenge. Assault weapons bans are falling in multiple circuits. Magazine capacity restrictions are being struck down using the same historical analysis. Waiting periods are being challenged as lacking any founding-era precedent. Laws declaring vast swaths of cities as sensitive places are losing in court. Training mandates and fees are being challenged as unconstitutional burdens on rights. The ruling didn't end the fight. It opened a floodgate of offensive litigation where gun owners are finally challenging restrictions that stood unchallenged for generations. This represents more than a legal victory. It's potentially a turning point in American constitutional history. The ruling doesn't balance your rights against government preferences. It restores rights to their proper status. It declares that gun rights deserve equal protection with speech, religion, assembly, and voting. It challenges a century of legislation built on fear rather than constitutional fidelity. It sends clear signals to every judge that defending liberty is their primary obligation. It reminds politicians that the Constitution isn't a suggestion or aspiration, it's binding law. The Supreme Court has reset the rules. States are panicking, resisting, or grudgingly rewriting laws. Gun owners are standing on newly solid constitutional ground. But this isn't the story's conclusion. It's the opening chapter of a much longer struggle. The court has clarified the law, but politicians are already plotting their next moves. The battle over what the Second Amendment means and how it applies to modern society will continue in courtrooms, legislatures, and elections for years to come. What's different now is that the constitutional foundation has shifted decisively. Rights that were treated as negotiable privileges are being recognized again as fundamental guarantees. The framework for evaluating gun laws has been transformed, and millions of Americans who once navigated a confusing maze of subjective restrictions now have clearer legal footing. The fight continues, but the battlefield has fundamentally changed.